Judgment in the matter of Mitchell and Alba against Sheikh Mohamed bin Issa al-Jaber.
This appeal concerns claims by the liquidators of MBI International and Partners Incorporated, whom I'll call the company. The claims were made against Sheikh Mohamed bin Issa al-Jaber, whom I will refer to as the Sheikh. He is an international businessman. The claims are made against him for breach of fiduciary duty in relation to the transfer of shares out of the ownership of the company, and also against JJW Guernsey Limited, another company associated with the Sheikh, as a knowing recipient of those shares. In March 2009, the company acquired about 891,000 shares in another company associated with the Sheikh called JJW Incorporated from other companies within the Sheikh's business empire. The shares were transferred to the company in return for sums of money which, under the share purchase agreements, were to be paid on demand in such a way that was mutually agreed. Payment of those sums has never been demanded, and no sums have been paid. I refer to that transaction as the March 2009 share transfers. The company, which is registered in the British Virgin Islands, was wound up in October 2011 by the Eastern Caribbean Supreme Court on the application of a creditor. At that time, the company remained the owner of the 891,000 shares. BVI company law provided that on the winding up, the Sheikh's powers as a director of the company came to an end. That notwithstanding, in 2016, the Sheikh purported to transfer the 891,000 shares from the company to JJW Incorporated, signing the share transfer forms, and I quote, for and on behalf of the company as its director. The forms were backdated to 2010, before the winding up of the company commenced, and I refer to that transaction as the 2016 share transfer. Thereafter, in 2017, all JJW Inc.'s assets and liabilities were transferred to another company associated with the Sheikh, JJW UK, and I'll refer to this transaction as the 2017 asset and liability transfer. The effect of that transfer was that the 891,000 shares, which had been the subject of the 2016 share transfer from the company to JJW Guernsey, became worthless because JJW Inc. no longer had any assets. In 2019, the company's then liquidator commenced proceedings, legal proceedings against the Sheikh and JJW Guernsey, arguing that the 2016 share transfer was void, that the Sheikh had acted in breach of fiduciary duty to the company in bringing about that transfer, and that JJW Guernsey, the recipient of the shares, was a knowing recipient of them. The trial judge found in favour of the liquidators, ordering the Sheikh and JJW Guernsey jointly and severally to pay equitable compensation of €67,123,403 for the loss which the company had suffered, measured by the value of the shares at the time of the 2016 share transfer. The Court of Appeal upheld the judge's findings as to the liability of the Sheikh and the recipient, JJW Guernsey, i.e. that the Sheikh was in breach of his fiduciary duty and that JJW Guernsey was a knowing recipient of the shares transferred in breach of fiduciary duty. But the Court of Appeal overturned the trial judge's decision as to remedy, holding that no equitable compensation was due because, by the time of the trial, the 891,000 shares had become worthless because of the 2017 asset and liability transfer. Both the liquidators and the Sheikh appeal to the Supreme Court. The court addresses 3 issues on this appeal, 2 on the Sheikh's appeal and 1 on the liquidator's appeal. Issue 1 is whether the Sheikh acted in breach of fiduciary duty in effecting the 2016 share transfers. Issue 2 is whether the company suffered no loss because it had acquired the 891,000 shares subject to an unpaid vendor's lien. And issue 3 is, if not, i.e. if there isn't a lien, how should the company's loss be calculated? In a judgment written by Lord Briggs, Lord Sales and me, with whom Lord Stevens and Lord Richards agree, the court unanimously dismisses the Sheikh's appeal on issues 1 and 2 and allows the liquidator's appeal on issue 3. It reinstates the order made by the trial judge for payment of just over 67 million euros. The court's reasoning in relation to each issue is briefly as follows. Firstly, issue 1, the fiduciary duty issue. The court holds that fiduciary duties can arise ad hoc, including when a person, by his actions in dealing with the property of others on their behalf, takes upon himself the obligations of a trustee or fiduciary. This may occur in circumstances where the person has not made any conscious undertaking to act as a fiduciary or to consider the interests of the other person, and indeed where he has acted contrary to the other person's interests. It is not necessary for this rule to operate that a person hold title to or possess the other person's property. The rule applies to a fiduciary, such as a director, who does not hold or possess the company's property. The court rejects the Sheikh's argument that a single indivisible act, in this case the signing of the share transfer forms for the 2016 share transfers, cannot both create and breach a fiduciary duty at the same time. Issue 2, which is were there unpaid vendors' liens in the March 2009 transfers, the court explains that an unpaid vendor's lien enables an unpaid seller to retain an interest in property until the buyer has paid the purchase price. This lien arises by operation of law, but the parties to a transaction can exclude it. The legal question, which involves an objective assessment, is whether there is a clear and manifest inference that the parties jointly intended to exclude the unpaid vendor's lien in their transaction. This court upholds the judgment of the trial judge and the Court of Appeal on this issue. The trial judge found, in fact, that the purpose of the 2016 share transfer the purpose of the March 2009 transfer was to enable an initial public offering, an IPO, of the company's shares, which subsequently did not proceed. It was intended at the time of the March 2009 share transfers that the company would use the returns from the IPO to pay the price of the 891,000 shares in JJW Inc., which it had acquired in those transfers. The trial judge held that the existence of an unpaid vendor's lien would have prevented the IPO and therefore undermined the purpose of the March 2009 share transfers. The Court of Appeal agreed, and this court upholds their view. The third issue is, how should the company's loss be calculated? The court holds that a court, in calculating an award of equitable compensation, treats the appropriate date to assess the value of what has been misappropriated as an open question, which requires it to consider what is just and equitable as between the fiduciary and the principal. If a fiduciary misappropriates property under his fiduciary control, and the principal can prove that the property had value when it was misappropriated, the principal will have suffered an immediate loss of value. The burden is therefore on the defaulting fiduciary who relies on a subsequent event, and here the Sheikh relies on the 2017 asset and liability transfer, to prove that the later event has broken the chain of causation between the breach of duty and the principal's loss. The case law shows that a defaulting fiduciary cannot rely on a later event as breaking the chain of causation where the fiduciary has or may have played some part in bringing about that later event, unless he can give a clear and convincing innocent explanation for his role. In this case, there is sufficient evidence that the Sheikh had an involvement in the 2017 asset and liability transfer. The court rejects the submission that there needs to be an in-depth consideration of all the appropriate counterfactuals where, as here, the shares have been rendered worthless. We are here concerned with the loss of the value of the shares to the company, and that occurred in 2016. The court therefore allows the liquidator's appeal and restores the order of the trial judge. The court will now adjourn.